Stephen does, you go into a little bit more detail. I'm sure he does also, and you get how, a little bit about the facts and the injury and who was present, and make an appointment for the individual to see you.
Okay. Why is the facts, or why are the facts so important?
Well, you're trying to, first of all, you're trying to give the prospective client an idea of whether this is a case that they can go forward on or not. You don't want to give them the idea that every case is compensable, because they're not. And of course, it's not every case that you're going to take as a lawyer either. And it depends on the facts. If you establish that there's not even a reasonable possibility of recovering, then chances are it's not a good case for you to take or for the client to proceed on.
Us lawyers and claim supervisors and adjusters, we call the whole area of whether or not there is a case, we call it liability, good liability.
Right.
And in addition to that, it also means negligence.
Right.
So somebody has to be negligent, is that right?
That's correct.
Okay, and so you have to evaluate the facts as you first hear them,
right,
without substantiating them. So if a client says to you that somebody hit him in the rear, you have no knowledge unless you ask the question, did you immediately cross into his lane at the last second? Did you make a sudden stop? Were you on the cell phone at the time, or where were you coming from because you're looking to see if there was any alcohol involved? That would all be a fair statement, is that right?
Absolutely.
Okay, and when talking to a client, you have to have them come in, is that correct?
Correct.
If they don't have an injury, do you take the case?
No.
Okay, and that is because?
Because it's not going to be compensable for the injury. If they are only having a property damage claim, they don't need